welcome everybody. Thanks ever so much for joining us. You're here, in case you don't know, you're watching one of DWSN's series of technical insight webinars. So we are here to talk about a particular subject that causes lots of queries for us a lot of the time. So I think we should, you'll definitely find it of interest. DWSN, just as a bit of background, in case some of you haven't been to these videos before, is the trade organisation that represents the producers of the CON29DW residential and commercial. So the water companies of England in the main instances anyway. So if we move on to the next slide, Karen. Yeah, that's me. So my name is Owen Davis. I'm the chair of DWSN, and my day job is down in Severn Trent Searches, bang in the middle of the country. And if you move on to the next slide, we can introduce you, because you are probably not the person that everyone was expecting to see necessarily. So Johnny, who's previously done the, there's a shocked emoji at the bottom of the screen there from somebody. So Johnny, who normally presents these alongside me, well, he does all the work really, doesn't he? Let's be honest. It was not available today, unfortunately. So Karen McCormack, who's another director of DWSN and day job runs the search business at United Utilities, has stepped into the void to take place. So welcome, Karen. So we're going to look at the really big questions, such as what are we both looking at in those photos? No idea, but clearly looking at the same thing. Understanding buildovers. As I said before, buildovers we get more queries about probably than anything else. It's a real big deal for people wanting to buy a home, and there's a lot of issues with it. So I am expecting a number of questions from you, which we will do our best to answer as we go on. But without further ado, let's move on to the next slide. This is what we're going to cover off. Just understanding what buildovers are and what's in the CON29DW. Really, what is the risk for those home buyers? That's what we're going to be trying to talk about today. So you plough on. I think I've already said this. This is a bit about us as an organisation, but like I say, the main thing you need to know is that we represent the producers of the CON29DWs. And I think that probably takes us through to you, Karen. So I'm going to hand over to Karen there, who's going to do all the technical bit, and then if there are questions as we go through, I'll be monitoring those. Please feel free to type them into the Q&A section, which should be open, and if it's appropriate, I will raise them as they come up if they're relevant to what we're talking about at the time, or I will answer them at the end. And also there'll be a couple of polls at the end, which I'll tell you about close to the time. But over to you, Karen.
Thanks, Owen. So as Owen's already said, in today's session, we're looking at question 2.7 from the CON29DW. And that question is, has a sewerage undertaker approved or been consulted about any plans to erect a building or an extension on the property over or in the vicinity of a public sewer, disposal main or drain? So what is the purpose of this question? Well, when purchasing a property, your client may well be planning to add, for example, an extension or conservatory to their property. They'll need to know if any public pipework is running through their property boundary and what it may mean for any further development, as this could influence their purchase decision. This applies whether the property is residential or commercial. So if there is pipework in the boundary and a property has already been extended, then your client will need to confirm. Then you will need to confirm for your client that any such extension or development had appropriate planning permission. That will also include checking if a build-over was consulted on. I will cover off on the next slide about the relevant building regulations. So any potential implications can be costly. Any buildings or extensions erected over a sewer in contravention of building controls may have to be removed or altered. Understanding the response to this question is essential before purchasing the property, as the new owner may be held liable for any costs if the building needs removing or altering. It is very rare though, but it's something to note. Okay. So, what do you need to know about the building regulations and what is the relevance for buildovers? Well, if a development, including extensions and conservatories, are subject to national building standards outlined in the H4 building regulations, and I've included the link there if you want to have a read of them yourself, then the homeowner will likely need permission to build over or within 3 metres of the centre line of a public sewer from the local sewerage undertaker. The relevant section is Part H4 of the building regulations, and this covers building over sewers, drains and disposal mains to ensure that the proposed work doesn't damage the sewer and still leaves access for maintenance and repair. The work must not overload the drain, and H4 includes guidance on diverting sewers when needed. Now, restrictions can be placed on developments, and they can include a 3 metre protected strip, which is the area 3 metres either side of the centre line of a sewer, as detailed in the building regulations. The size and depth of the pipe and the size of the development will determine if permission to build in this area is needed. Okay, legal easements. Some pipes are protected by legal easements. If an easement exists on a pipe that crosses the homeowner's land, then this should be included in the property deeds, and therefore you can make your client aware of this prior to purchasing the property. Easements exist to make sure water and sewerage undertakers can effectively operate and maintain their pipes. The terms of the agreement will usually detail any conditions associated with building within the easement area. So a build-over agreement, a build-over agreement, Okay, so a build-over agreement is an agreement between the sewerage undertaker for the area and the homeowner that gives the homeowner permission to build over a public sewer. It may be subject to stipulated conditions such as providing statutory access to the sewer for maintenance. Remember, if permission has not been sought ahead of any development and it is found to be in contravention of Part H4 of the building regulations, then the sewerage undertaker, in extreme cases, although it is very rare, can request for the building to be removed or altered. That will be at the current homeowner's expense, so it is essential to know prior to completing a purchase. Okay. So in the next couple of slides, we'll just go through some of the common responses for buildovers in the CON29DW. One of the common responses in a search is none, and that means that the sewerage undertaker has never been consulted or provided approval for a buildover. Now, it may be that the approval was never required due to the size of the sewer or drain, rather than permission not being sought. But it's always worth checking ahead of any purchase, as the purchaser may be held liable. So in the examples on screen, the response to question 2.7 was responded to as none. In both examples, you can see that there is no public sewer under any of the buildings. However, in this one on the right-hand side, you can see that the foul sewer runs close to the building, but not under it, and the manholes are accessible too. So one other consideration is that following the private sewer transfer on the 1st of October 2011, there may be private sewers and lateral drains that have been built over that have now transferred into public ownership. Historically, when these assets were private, there was no requirement for a build-over agreement. Now that the sewer or drain is in public ownership, it may be necessary to apply for a retrospective building agreement. It's always worth checking with the property sewerage undertaker though. Okay. Another common response is approved consulted. So if there is a public sewer or drain running under a building in the property boundary, then it's useful to have confirmation that a build-over agreement was applied for and put in place ahead of purchasing the property. Okay, so now in the examples provided here, both have a building over agreement in place. In the first example, you can see that the public surface water sewer runs under the edge of the property, but the access manhole is out in the street, and so there is no access restriction. In the second, the combined public sewer runs under the property. Initially, this build-over consultation was objected to as the 150mm diameter combined public sewer was recorded as being within 3 metres of the proposed structure. Upon further consultation, consent was given to the development on the request that all works satisfied the regulations of Part H4 of the building regulations. So if your client wants a copy of the build-over agreement, then it is possible to get a copy from the sewerage undertaker, but there is generally a fee involved. Again, you'll need to check with the relevant sewerage undertaker about that. Okay, so the last response I'm going to cover is rejected. We don't see as many rejected responses as the sewerage undertakers will try to accommodate most applications and will only reject an application where it puts the sewer at risk of damage or restricts access for maintenance. So in this example, the application to develop a school site was rejected. The reason given was that the current records indicated that the proposed development will be directly over 150mm diameter combined sewer, which was less than 1 metre deep, and the associated manhole access point. Although the build-over was rejected, a modification of the site layout or diversion of the affected public sewer at the applicant's expense is a possible consideration. So the takeaway here is that a rejection doesn't have to put an end to any development or extension. It may just add some additional costs. Okay, so this is just an example of what can go wrong and why it's important. Now, fortunately, it's very rare, but it is an example of how things can go wrong. So this was quite some time ago now. But there was a blockage in a sewer pipe that led to the discovery of a manhole cover beneath the lino in a kitchen extension. When the manhole was loosened, the pressure of the blockage caused the manhole to fly open, and it actually led to the kitchen being flooded with sewage. So not a very nice experience. If a build-over application had been submitted when the extension was being built, the requirement to grant the build-over would likely have included relocating that manhole access point to the outside of the property. Now, it is an extreme example of why it's always important to check if there are pipes running in the property boundary or under the property, but it's a good pointer to check if a build-over was consulted on if you do see any pipes in the property boundary. Okay, so just want to summarise what we've covered today. So again, question 2.7 is a key question. It will confirm if the sewerage undertaker has approved or been consulted on any proposed plans to build over or near to a public sewer or drain. Excuse me. It's included in the search as the presence of public assets running within the boundary of the property may restrict further development, and so your clients need to be aware ahead of any purchase decision. It's also worth knowing to ensure the correct planning application has been followed and the build-over agreement obtained if required. Remember, any buildings or extensions erected over a sewer in contravention of building controls may have to be removed or altered, and it would be at the expense of the homeowner at the time the contravention was found. Whether or not they put up the extension. It's rare that this would happen, but it is an option for the sewerage undertaker, so it's always worth that investigation. Okay, That's all I was going to cover today in terms of build over. Just putting this slide up again as a reminder of the support that's available from the DWSN. We've got our website at www.con29.co.uk. You can find the postcode lookup there if you want to know who your CON29DW supplier is. We've got a list of the DWSN members, and you can check out our YouTube channel for more webinars that we've done in the past. Okay, so just move on, and if anyone has any questions they'd like to ask.
There's a couple of them already there, Karen, thank you for that. So does a building reg certificate negate the need for a build over agreement, was the first one. So, I mean, it's effectively the same thing. You know, if the statutory sewerage undertaker has been consulted as part of getting the building regs approval, then that is basically a build over agreement from the sewage undertaker. So if you have that building reg certificate, then you're pretty safe and sound on that one. Another one, would this be something that a flooding team could consider? For example, what would be classified as an internal flood. However, if no build over agreement was carried out, then it's the customer that's caused their own issue due to carrying out illegal extension works. I hadn't really thought about that one before. Any ideas, Karen?
I'm not sure on that one, because if it was just a blockage that wasn't so internal sewer flooding is recorded when the sewer pipe is unable to cope with the load due to hydraulic inadequacy. If it is an internal blockage that's caused it, then it wouldn't be classified as internal flooding. From a water company perspective, it's only if it was due to hydraulic inadequacy.
Yeah. Okay. I'll have a think about that one as we're talking about that. Thank you for that question. Another one, in terms of extensions over former private sewers, now public, if the extension is building control sign off, would a retrospective build over agreement still be needed?
I would
Probably.
assume no, because you should have
exactly.
You would have complied with the building regulations.
Exactly. Yeah. I mean, there's loads of these obviously now because of the sewer extension. The sewer transfer that Karen mentioned previously. So a whole load of sewers that were previously private are now public and had been built over when they were private, with no need for getting approval in the same way, but they'd still need building regs for the extension. So it would still have taken into account the fact that there was sewers underneath it and that sewer needed protecting. So you know, as part of the building regs, that would have happened. So I don't see a real situation in which, you know, the sewage undertaker would demand a retrospective build over agreement, because if you have already got building control sign off. So no, I don't think so. I mean, look, I want to be absolutely clear about this. You know, some of these, certainly there's the older build over agreements that used to exist sort of pre-2000 were incredibly one-sided agreements that meant that, you know, if you got one of these build over agreements, you were basically telling the sewage undertaker, you know, that we're going to build this extension, but if something goes wrong with it, with the sewer underneath, you've got the right to come and knock down my extension at my expense, which is utterly ridiculous. So loads of people didn't sign them, unsurprisingly. It's all changed now under the building regs proposal, but that's how it used to be. So there were lots of extensions where people just didn't get permission back then to build over those sewers. But the process is so much clearer now in terms of what's required to protect that sewer, whether you're putting lintels over it, whatever needs to be done to ensure that that sewer is not damaged. And then obviously doing CCTV surveys before and after you do any building will be one of the requirements that happens as part of that as well, to ensure that no damages happen to it. But look, a water company's not going to come along and, you know, knock down an extension and then, you know, charge you for it, and that would be, you know, terrible PR, frankly, at a time when water companies don't need any more terrible PR, let's be honest. So it's, that's the reality, is that if anything needs to be done to that sewer underneath an extension, they will come and do it, absolutely, but then they will put everything back exactly as they found it, because we do not need to be in the newspapers for any other reason. So yeah, that's the reality for your clients anyway. I mean, Bill, I think it's just asked a question. Please run over again pre-2011 private sewer built overs requirements to apply for retrospective consent. Again, so yeah, that's sewers that were, you perhaps didn't have permission pre-2011, now needing retrospective consent. Yeah, that, as Karen said in this, that could happen. If it didn't get consent originally, then you might have to go and do that. And the things that would be required were exactly as I said. You need to do CCTV surveys to ensure that the pipes are in good nick and everything's been built properly. I'm assuming that's what you're referring to there. Hang on. We're getting loads of questions, as I anticipated. James Ferguson, it's common for Victorian era terrace properties to have sewers running under their rear kitchen area of their properties. Does that mean post 2011, all these properties will need to apply for the same question again, or retrospective build over agreements? I
would say with the terrace properties, any manholes will be outside of the building, and so it's unlikely to be an issue.
It's unlikely to be an issue, but I guess you might come into a situation where there is an issue and you end up having to retrospectively apply for it. But I wouldn't just do it as a matter of course. I don't think there's any need to do that in that particular instance. Right, there's another one here. An extension was built over a private sewer before 2011, which became a public sewer in 2011. Is a build over agreement? It's the same question again. I was told in the past that it wasn't. Yeah, I mean, no, you haven't got everybody that had a private sewer built over needing, as I say, getting that retrospective permission, because it would have had, that extension would have needed building regs at the time anyway, irrespective. So under the building regs, that would, would be fine. So no, you don't need to automatically apply for retrospective build overs.
I think got another question from Asil Rashid.
Yeah, just to be clear, if you have building regulations, you do not need a build over agreement. And what if there's no building regs, that you took on an indemnity insurance cover for lack of building regs? Well, that's, yeah, I mean, and obviously I understand that people do buy insurance in those instances where building regs hasn't been taken, and that's what that insurance is for, I guess, to cover you off in an instance where there is a problem and they come in, building regs wasn't sought and there's an issue, and some enforcement is taken on that particular property. That's what you buy. That's what you're buying that insurance for. But as I say, even in those situations, if there's a problem with the sewer, the water company doesn't just come down and I know it can, in theory, come and demolish your extension and to get access to a sewer. In reality, that doesn't happen, obviously, for all the reasons I've already said. I wouldn't panic about that happening, but it is in those instances, occasionally it might be worth getting indemnity insurance to cover it off if building regs wasn't sought, because you'd do that anyway. If an extension didn't have building regs, and you were purchasing that property, you'd want some sort of indemnity policy in place, as you would for anything else that didn't have building regs. Anything else, a loft extension, whatever that didn't have building regs, you'd want an indemnity policy to ensure that if there was a problem with it, to indemnify you against enforcement action from the local authority. But that's the first part of the questions. If you do have building regulations, you don't need a build over agreement. That's what we're talking about, because it would be part of it. Yeah. Any more questions at all? I don't think I've missed any, have I?
No, I think that's everything.
Right. So I completely forgot to say that there are 2 polls going live at the end of this. So if you look at the polls button there should be one which is just about how satisfied you are with the webinar, which has just popped up on my screen now. And there should also be one about what you might like to see in the future in terms of webinars. So what topics you'd like us to cover, because trying to be audience pleasers here. We want to know what you want to hear about, because then we'll tailor our presentations accordingly. So any feedback you can give us is extremely welcome. And we'll use that to tailor what we do going forwards. But so 82 people on. I think it is a record, Karen, I have to say, for the number of people. I hope we met your expectations on that regard. Hang on, there's another post come in. Just further to that, they've essentially caused it to become an internal flood as opposed to an external, which is a much larger fine from Ofwat. Sorry, added as a comment, and don't think this highlighted. Sorry, Craig, you're absolutely right. I didn't notice that. Probably should have spotted it under the comments. Yeah, that's a fair point. Karen, you got any thoughts on that one?
Sorry, could you say that again? I missed.
Yeah, it's further to the question we talked about. You talked about internal sewer flooding previously, and Craig's sort of saying they've essentially caused it to become an internal flood as opposed to an external flood, which is a much larger fine from Ofwat, affected by building over where it's flooded. So, yeah, I get what you're saying.
Apologies, I was looking at it from the point of view of the water company and whether we'd record it as internal flooding.
Okay, so Bill's saying, sorry, there seems to be contradictory replies regarding building over pre-2011 sewers. One, if building regs granted at the time, it is said that retrospective consent is not needed. And in a general statement that building over a pre-2011 private sewer could need retrospective consent, which is right. Well, if you built over a pre-2011 private sewer and didn't get permission, didn't get building regs, obviously then you might need retrospective permission. But if you had building regs at the time, then you don't need to get retrospective consent. You agreeing with that, Karen?
Yes, yeah. If you've got a building control certificate, then that's saying that you've complied with building regs, and therefore you would have complied with Part H4 at the time.
So in answer to that, one is correct in your response, Bill. Sorry if I've not been clear about that. So yeah, if you've got building regs, got that building control certificate, then we're good to go. You don't always have to get retrospective consent if it's pre-2011. But if there wasn't building regs for it, then you'd want to seek that and ensure that it was done properly, because it might not have been, obviously. Hope that's clear. Feel free to send any further inquiries or questions you might have through to us. I'm trying to think what the best email address to do that on would be, Karen.
It would probably be, if you go to the website, there's a contact us form. So if you go to the DWSN website, www.con29DW.co.uk, and there's a contact us form if you've got any further questions.
So if you put them in there, then we can go over them. We have just got one more thing in. What if the works did not require building regs at the time the works were carried out pre-2011? So if it didn't require building regs, then you'd have no guarantee that the sewers have been protected in the way they should have been. So in those circumstances, it would be worth applying for retrospective consent, because there's no building regs.
Got another question.
What is the position if someone had placed decking? Do you need a build over agreement? Will the slides be emailed over? Good question. Have we got the details of everybody so we can send slides out?
Yes, we will have the details, and we can send the slides across. And the webinar, the recording, will also go up on the YouTube channel.
So yeah, we've got a DWSN YouTube channel, so that will be showing this recording afterwards. Oh, in terms of the decking, I don't think you need it for decking, do you, Karen?
No, I wouldn't have thought, with decking not being a permanent structure.
Exactly, and it's not. They won't go deep enough or be heavy enough that they're in any way going to have any issues with that. So no, I don't. I've never heard of that. So no. Oh, I've had difficulty connecting. Are you going to send notes and a copy of this? I think we just answered that question. So the recording of this will be on the DWSN YouTube channel. So just Google that and you'll be able to find it. There'll be links to it on the website previously stated, www.con29DW.co.uk. Yeah, so you'll be able to see both the presentation and the link to the YouTube channel there. And please, as I say, please feel free to email any further questions to us in the contact details on that website. And if you could answer the polls, that would be really, really useful for us as well. And we've just run over time now, so we've just gone 2 minutes over. So I want to thank everybody for joining us. I know how precious time is to everybody. So to get 80 odd of you over listening to this has been fantastic. So hope you'll join us at our next one, and we'll send out details of that as soon as we get them. Thank you.
Thanks very much.